The agreed terms are as follows: no finding of family violence and no non-disclosure for either party. The parties will be joint managing conservators, with Ms. Gordon as the custodial parent with the exclusive right to designate the primary residence of the child, with the geographic restriction to Collin County and contiguous counties. Child support will be $418 per month beginning April 1st, 2026. Medical support will be $131 per month beginning April 1st, 2026. And Ms. Gordon will be ordered to obtain or maintain a government health plan. Retroactive support as of March 19th, 2026, judgment amount and the amount of $6,235 to be paid off at $80 per month starting April 1st of 2026. And of course, the non-custodial parent would be assessed the court costs 1 year from today's date.
At the start of the hearing, the court outlined the full agreement between both parties. There was no finding of family violence, and neither side requested confidentiality restrictions. Both parents were appointed joint managing conservators, with Miss Gordon given the exclusive right to decide the child's primary residence. This residence would be limited to Collin County and nearby counties. The father was ordered to pay $418 per month in child support starting April 1st, 2026, along with $131 per month for medical support from the same date. Miss Gordon was required to maintain a government health plan for the child, with retroactive support beginning March 19th, 2026. Additionally, a judgment amount of $6,235 would be paid off in monthly installments of $80 starting April 1st, 2026. Court costs would be assigned to the non-custodial parent after 1 year. After confirming these terms, the court called Miss Gordon to testify. She confirmed she was not married at the time of the child's birth and identified Michael Riziki as the father, stating no one else could be. She agreed to all the terms and expressed no safety concerns about her contact information being included. Mr. Riziki was then called, and he acknowledged he was the father and agreed to all terms as well, with no safety concerns raised.
Of the agreed terms, the state will call Ms. Gordon first. Ma'am, did you hear the terms I announced to the court just now?
Did.
And were you married to anybody at the time that the child was born?
No.
Who is the father of this child?
Michael Riziki.
And could anybody else be the father?
No.
Are you in agreement with those proposed agreed terms that I just read into the court record just now?
Yes.
And do you have any safety concerns if your contact info appears in the order?
I don't believe so.
Okay. I'll pass the witness and I will call Mr. Riziki. Sir, did you hear the agreed terms that I announced to the court just now?
Yes.
And do you admit or acknowledge that you're the father of this child?
Yes.
Are you in agreement with my proposed agreed terms so far?
Yes.
Do you have any safety concerns if your contact information appears in the order?
No.
All right, I'll pass the witness and ask the court to accept the agreed terms.
Okay.
And I will recall Miss Gordon on the issue of visitation. Ma'am, how old is the child before the court today?
He is about 2.5.
And when does he turn 3?
He turns 3 October 24th.
Is he talking yet?
Not really. He only says a few words.
Okay. Now, it's my understanding that you are requesting, or you are okay with, the standard possession order starting from when, normally it's when the child turns 3, but you're requesting that it either start when the child turns 4 or when the child is able to communicate effectively. Is that right?
Yes, that is correct.
Does Mr. Riziki see the child regularly?
He sees him once a week for a few hours.
And does he ever get any unsupervised visitation with the child?
Usually, no. It's only happened a few times.
Okay. What are your concerns with the child if Mr. Riziki were to have unsupervised visitation?
I don't really worry just about him. It's just some of the people that he's around. I don't think Michael would ever do anything himself to harm him.
So
But then
specifically,
again, sorry, I interrupted you. I just
um,
also don't completely.
We're not understanding
understand.
anything either of you are saying because you're talking on top of each other. So
sorry.
hold on. Let him ask you another question. Okay.
Okay.
Go ahead.
Thank you, Judge. Sorry about that. So Mr. Ruzicki himself, you don't believe he's a safety concern to the child in any way, right?
No, I do not. He just tends to lie, so that's the only thing that I don't trust.
Okay. Um, but I mean, you don't think that he will physically harm the child, be doing drugs or drinking around the child or anything inappropriate or anything like that. Is that right?
No, I do not think that he'll do that.
Okay. Um, it's my understanding that one of your main concerns has to do with his current spouse. Is that right?
That is correct.
What's her name?
Lauren.
Do you know if Lauren drinks or does drugs or anything like that?
I know she did before she got pregnant.
She did what?
She drank before she got pregnant and had to go to rehab.
Okay, so it's your understanding that his current spouse was an alcoholic.
Yes, before she got pregnant. Yes.
Okay, are you requesting?
Discussion then shifted to visitation arrangements. Miss Gordon explained that the child was about 2.5 years old and not yet speaking clearly. She requested that standard visitation begin later than usual, suggesting either age 4 or when the child could communicate effectively. She confirmed the father currently saw the child once a week for a few hours, mostly under supervision. When asked about her concerns, she clarified that she did not believe the father himself was a danger, but she worried about the people around him. She specifically mentioned his current spouse, Lauren, stating that Lauren had a history of alcohol use and had attended rehab before becoming pregnant. Because of this, Miss Gordon requested that Lauren not be left alone with the child, at least until a standard visitation schedule was in place. She also expressed a general preference for supervised visits and wanted to ensure the child was not exposed to drinking. Despite her concerns, she admitted she did not believe the father would harm the child or behave inappropriately. Her testimony focused mainly on caution and the child's young age rather than direct accusations.
That the court, if the court orders or permits Mr. Ruzicki to have any sort of unsupervised visitation with the child, are you requesting that his wife, Lauren, not be permitted to be around the child unsupervised?
Yes, at least until we do the standard possession order.
Okay, so you're saying once the child is old enough, you even then wouldn't mind the wife being around the child unsupervised?
Oh, just her and Clifton?
Yes.
No, even then I'd probably still prefer
Okay.
for Michael to be around.
Okay. What were your other requests as far as visitation prior to the standard possession order kicking in?
I believe it was just the supervised versus unsupervised, and then the age. I can't remember what else I put down. I believe I put, I request that he not drink around Clifton, but I don't feel like he will do that.
Is there anything else you'd like the court to know?
Not at the moment, no.
Okay. I'll pass the witness and call Mr. Ruzicki. So you actually, it's my understanding you have a newborn. How old?
3 months.
With your current wife?
So, Mr. Ortega, we didn't understand the answer. Sir, get closer to your microphone. We're having a really hard time understanding you.
Okay.
Okay. How old's the child?
15 weeks.
Okay. Congratulations. And that's with your current spouse, right? With Lauren?
Yes, sir.
Is the baby vaccinated?
In the process, he's been vaccinated for most things, but there's the second half he has to do, and you can't get measles until a year.
So I understand that was kind of one of the points of contention, and that it's your intention to keep the child separate until your newborn baby is able to get that measles vaccination at 1 year. Is that right?
Yes, sir.
Um, is what Miss Gordon said correct, that you're visiting Clifton, the child on this case, fairly regularly?
Yes, sir.
Where do those visits occur?
Most of the time, for a large portion of time, they were at her house, and then we transitioned to my parents' house, just so he could get to know his grandparents and stuff.
Okay. And you're requesting to be able to have unsupervised visitation with the child so you can take him to a park or McDonald's and not be restricted to the grandparents' home. Is that right?
Yes, sir.
Do you have any objection to the mother's request that your wife, Lauren, not be permitted unsupervised possession of the child?
Alone?
Right.
No, I would respect her request. I do think it's a little overzealous, but
Right.
out of respect for the mother, I will acknowledge that.
So you feel it's probably not necessary, but you're willing to.
Yes.
Okay. Is she sober, your wife?
Yes, well over a year in recovery.
Okay. And you have no objection to the standard possession order. Again, it normally would start when the child turns 3, which would be later this year in October. But mom is requesting that to standard possession order starting when the child turns 4 or is able to communicate effectively. Are you in agreement with the mom's request as far as that goes?
I think he will start speaking more fluently very soon. I think 4 is a little, again, over.
Okay, so let me jump in because I'm confused. Dad, tell me, what do you want today? Do you want standard visitation today?
I just want what's best for Clifton, for our son.
It's your turn to tell me. What is it you want?
I want to be able to, I won't be taking him to my house personally due to vaccinations, but I would like to be able to take him out to get lunch, go to a park, go to a movie, whatever it may be. I don't want to be just having to be stationary at my parents' house.
And you're okay, at least until standard possession starts, you're okay for now being not having overnight yet. Is that right?
Yes, sir.
And so, sir, when do you want the overnights to start?
I would guess when standard visitation becomes applicable.
So if I order that's next weekend, is that what you want?
I could do that. It would be difficult though, because I can't navigate that with an unvaccinated child at my newborn's house, and I can't just go leave my house to go to my grandparents' house for a couple days, or his grandparents. It would be very difficult.
And
I
so
work a
what are you
full-time
going to
job.
So what are you going to do when the child is 3? If standard visitation starts when the child is 3 in October?
My newborn will have all of his vaccinations, and then he could stay at my house potentially.
I'm sorry, then when do you believe that will take place?
When the vaccinations are complete, at 1 year of age, when MMR becomes viable.
And sorry, when is he 1?
In December of this year.
In December of this year. But I'm not talking, if the child 2.5 now, I'm talking October of this year. If the child turns 3, October the 24th, so what would you do?
I could make it work for a couple months, but you know what? Maybe we can keep it at 4. Maybe that's fine out of respect.
If I may, Judge.
Yes.
At one point, I had a proposal that started the standard possession order starting January of 2027, because that would be after the newborn has turned 1 and should have gotten all of their appropriate vaccines at that time. I just felt like that was an idea that made sense for their respective concerns.
Accept and approve the portions of the agreement that the parties have agreed to. And then regarding the only contested issue, which was the visitation schedule, Mom, Dad, you can do anything that you agree to, okay?
Yes,
But
ma'am.
I'm not veering at this time from I'm going to give Dad a standard possession order for parties that live 50 to 100 miles from each other now. And then when the child turns 3, Dad will have the visitation for parties that live within 50 miles of each other.
Okay, I see.
Okay. And this includes overnight. So you guys are going to have to make some arrangements to either make agreements that Dad gets some hours on Friday, some hours on Saturday, and some hours on Sunday on his weekends. Okay. If you're not going to do overnight, you're going to have to communicate and figure that out. Okay. On the other hand, if mom needs to work 1st, 3rd, and 5th weekends, and Dad may need to get grandparents to help out. Okay. So you guys have got to work together on this. I will, based on the agreement of the parties, council, please include a provision that the stepmother, this is not that she's supervised, but the stepmother will not be left alone with the child. So she can be around the child, but she's just not going to be left alone. If Dad has to work all day or whatever, she will not be left alone with the child. And we'll put that provision in now based on your agreement, and maybe you guys will reach a different agreement down the road regarding that, depending on what the situation is. Okay, so Mom, Dad, I'm going to ask council to draft up your agreement and then include that portion that I've ordered regarding the visitation. Send that to me. I'll sign off on it, and then you both are going to get a copy of that. Okay? Okay. Thank you both. You're free to go. You can just hit that button that says leave or leave meeting. Thank y'all.
When Mr. Riziki testified, he explained that he had a newborn child with his current wife and raised concerns about vaccinations, stating he wanted to keep the children separate until the baby was fully vaccinated. He confirmed he regularly visited his older child and requested more freedom during visits, such as taking the child to the park or out for meals, rather than being limited to supervised locations. He agreed to respect the mother's request that his wife not be left alone with the child, even though he felt it might be unnecessary, and confirmed she had been sober for over a year. During questioning, he admitted overnight visits would be difficult for now due to the vaccination issue, but said he could consider them later. The judge stepped in to clarify both sides' positions and ultimately made the final decision. The court ordered a standard possession schedule, adjusting it as the child grows older, including eventual overnight visits. However, until then, both parents were expected to cooperate and make practical arrangements. Importantly, the judge included a condition that the stepmother could be around the child but must not be left alone with him. The court finalized the agreement, instructed the attorneys to prepare the official order, and informed both parents that they would receive copies once signed. The hearing then concluded, and both parties were dismissed.